Good morning. Our first case up for oral argument this morning is United States v. Robinson and Swanson. Whenever you are ready, Mr. Rayfield, good morning. And I understand you're going to take 9 minutes, and then your co-counsel is going to take 3. Is that correct?
11 and 4, yeah.
For your opening, you want to save 2 for rebuttal.
Right, exactly.
Okay.
Thank you.
Whenever you're ready, please.
Sure. May it please the court, Mike Rayfield on behalf of Pierre Robinson. I want to focus on the 3 combined facts that make this case so unusual. One is that Anise Robinson remembered absolutely nothing about Mr. Robinson or her identification of Mr. Robinson. 2 is that nothing in the record suggests that she was feigning her memory loss. And 3rd is something that, frankly, I wish we'd highlighted a little bit more in the briefs, which is that unlike all of the cases where courts have faced an issue like this, the only reason Anise was at this trial was to verify her identification. She was there to address one topic and one topic only, and that was the topic on which she was cross-examined on. That makes this case different from this court's decisions in Schaefer's, Cookson, the Supreme Court's decision in Owens, and even the Mississippi Supreme Court's decision in Gopher.
Why would that matter? Why would, if you're there for more than one topic, be relevant if you can't remember any of the topics?
Well, because at least when the witness with memory loss is someone who was at least involved with the events in question, you can ask that witness questions related to the event. So take Owens, for example, where the witness remembered getting assaulted at the prison, but he couldn't remember why he believed that at the time that it was the defendant who assaulted him. You could still ask a witness like that, for example, well, were you near the defendant's cell that day? Had you ever met the defendant before? How many times have you encountered him? Was there anything distinctive about him that would stand out even while you're getting assaulted? And depending on the answers that you get, you might be able to demonstrate that the witness was unlikely to make a positive ID at that time. With Anise, the defense couldn't cast doubt on her ability or her incentive to identify Robinson in 2015.
Well, the incentive, they asked a lot of questions about bias. And she was able to answer those questions about relationship with the store owner, relationship with the victim's family members, her own involvement with gangs. Those all went directly to bias and potential incentive.
Well, the only question that she answered, the only bias-related question that she answered in the affirmative, in a way that would somehow actually suggest that she was biased, was her.
Well, it's not how you answer it. It's the question was posed. There were plenty of questions about bias posed that she was able to say yes or no to and elaborate on, and not say she couldn't remember.
I respectfully disagree with that, because I think the questions that are posed are not what's important. Attorney questions are not evidence. If she's answering questions, I don't know, that's not evidence.
But she was able to answer many of the bias questions about prior gang membership, relationship to store owner, relationship to family members, those type of questions. So it's not that the answers are the evidence, you're absolutely right, but the fact that she was able to answer it, maybe it didn't show bias in her answer is not what matters, but it's the fact that she was able to answer it.
But I would disagree with the idea that she was able to answer many questions. There were really only 3 categories of questions that she was able to answer. One was about her relationship with the victim's sister,
which goes directly to bias and potential incentive,
which gives rise to a potential for bias. One was about her membership with her gang membership, which she denied, and one
which again goes directly to bias. I mean, you don't like the answer, but she was able to answer it. So I don't think that whether the answer helps you or not is what's relevant. It's whether or not she was able to answer those cross-examination questions.
What's relevant is whether her answers in any way cast doubt on her ability to identify Robinson in 2015. I don't think any of those questions did. This is not the situation, say, in Schaefer's, where the witness was able to answer questions like things like gave answers about whether she was impaired at the time of the incident, whether she feared prosecution.
So I guess, Mr. Rayfield, my I'm curious, where would you draw the line then? You say that a witness needs to recall, have some memory of, that might be relevant. And, you say that here, the witness didn't have any recollection. And so what sort of recollection does a witness need to qualify under the rule that you're proposing?
I think that when the memory loss is genuine, as it is in our case, the witness has to, at minimum, remember the defendant, the identification, and the events surrounding the identification.
So take, for example, I was thinking about this in the context of the hearsay rules and, recorded recollection, right? So 8035 says that where a witness doesn't remember anything, right, they can basically attest to, say, if there were notes that they took near the time of the incident, they can attest to that. And as long as there's foundation that it accurately reflects the witness's knowledge, then it's admitted. Is your rule basically saying that that exception would not apply in any criminal case?
I apologize, Your Honor. I'm having a little trouble understanding the question. So the witness is able to take notes at the time?
Right. So either the witness takes... So the rule is on a matter that witness once knew, but now cannot recall, okay, was made or adopted by the witness when the matter was fresh in the witness's memory, and accurately reflects the witness's knowledge. So if you meet those standards, which I think she would here, then that past recollection recorded would come in, whether, under 803 at least, whether or not she remembered anything. And
right.
So is your rule then that 8035, which has been in existence for a long time, should not apply, it's unconstitutional as applied in the criminal context?
I'm not saying it's unconstitutional. I think you would have to ask the separate question of whether that testimony would comply with the Confrontation Clause. I think I'm not very familiar with the case law behind this rule. I apologize, but I agree that if there was no prior opportunity for cross-examination in that situation, then no, the Confrontation Clause would not permit such testimony. And I mean, I think that makes sense because the entire point of the Confrontation Clause is that you can't necessarily assume that a witness is going to tell the same story that she told before when she's actually forced to come into the courtroom, look the defendant in the eye, and repeat the accusation in the uncomfortable presence of the defendant. Anise, that never happened with Anise. She made her identification in the very friendly presence of a state's attorney and a police officer who were trying to get her help. I just want to emphasize that again, it's critical that the only reason the government called Anise was to verify her identification. In all of the other cases that the parties talk about in their briefs, the witness has something to contribute beyond just saying, I recognize this person in the video. In Owens and Cookson, the witnesses were the victims of the crimes.
But why does that matter? I mean, it's pretty significant. She watched the video that was taken at the store of the defendant who was convicted for this, pointing a gun and shooting somebody. And she was able to review the crime that was committed and say, I can identify that person. That's very significant evidence. I don't understand the distinction between, well, she wasn't there at the time he shot him. He shot the other person.
It's extremely significant evidence. I'm not denying that. I'm saying the very fact that it was so significant and that there was no other way for the defendant to undermine the statement is what really implicates the Confrontation Clause here. All you have to look at is what happened with the other witnesses who looked at the video and attempted to identify the defendant, to see what could have happened if Anise had testified. Regina Banks was one of the three witnesses. She came to the stand and basically completely fell apart. She couldn't identify Robinson in the video at all. Derek Swanson came to the stand and admitted that he couldn't identify Robinson based on his face, but only based on his walk and his clothing. Ciara Robinson, the third witness, could identify the defendant, but she couldn't. But on cross-examination, she had acknowledged that she couldn't. That one of the still images was too dark.
Mr. Rayfield, I want to switch gears real quickly because we're into your rebuttal time, but I can give you a little bit extra to the next topic. I am having a hard time understanding why you want to bring an ineffective assistance of counsel claim on direct appeal. And I want to make sure that you, and significantly your client, realizes that if you bring this on direct appeal, he cannot bring a separate challenge for ineffective assistance on collateral review. You don't get any further development of the record on factual issues. And we have said in prior cases that it is almost inevitable that defendants are better served by pursuing these claims on collateral review than on direct review. So I want to make sure you and your client really want to pursue the ineffective assistance of counsel claim on direct review and make sure your client is aware of those risks.
Yeah, I mean, I've obviously gone over that with my client. We think it is appropriately raised here because it's so closely linked to the Confrontation Clause claim. In every case where a court has denied relief based on a witness's memory loss, it has emphasized what counsel did extensively on both cross-examination and during closing arguments, and our position is that none of that happened here.
Okay, thank you. I'll give you your 2 minutes back for rebuttal since we took it. Mr. Roy? And Mr. Berry, good morning. I should have acknowledged at the beginning that you were appearing remotely and you were present, and I assume you can hear us okay.
I can. Thank you, Your Honor. Good morning.
Good morning. Mr. Roy, whenever you're ready.
Thank you, Judge. Good morning. May it please the Court. Opposing counsel, Attorney Michael Roy on behalf of Appellant Derek Swanson. I do not have a lot of time, so I'm going to get right to it. I just want to start by recognizing that this issue probably seems relatively unimportant, especially when attached to co-defendant's case. I realize we're like quibbling over one minor condition of supervised release that's going to go into effect 20 years from now. But there is an institutional benefit to reviewing these types of claims. I know I personally have had about half a dozen or so of these discrepancies between oral and written judgment claims. Many of them the government has either conceded or agreed to stipulated remand on them. It is a recurring problem, and only in these appointed direct appeals do we have another attorney actually reviewing the written judgments to check if they correspond with the oral rulings.
Why doesn't the written judgment here just clarify the district court's intentions with respect to which condition?
I think what's unambiguous is the judge's intent to prevent the probation officer from entering the workplace. I mean, defense counsel basically cleared his throat, and Judge Tharp jumped in and said, yes, I agree, I'm going to grant this objection. So Judge Tharp very clearly did think that it was a concern to not have probation interfering with the workplace. He would have been aware of the parsimony principle, known that conditions should be no greater than necessary for, in this case, it'd probably be rehabilitation, would be the sentencing goal. He wanted to ensure that Mr. Swanson was able to find employment, and it would have made more sense for him to be striking both conditions.
But there is a significant difference between the two conditions, right? With regard to when the probation officer can enter the workplace. Mm-hmm. With regard to 16, the probation officer can enter the workplace really at any reasonable time, given any reasonable notice, right?
Right.
And in 23, the probation officer needs something else, right? Needs reasonable suspicion, right? And so it seems reasonable for the court to make, and for counsel, frankly, to make that distinction between the two, because you don't want a probation officer just willy-nilly coming to your workplace. On the other hand, if you provide some basis, that seems like it's a whole different category.
I agree completely, Judge Lee, but I think they both have one common element, which is intrusion into the workplace based off of reasonable discretion of the probation officer. I mean, reasonable suspicion is a relatively low bar. It's like a Terry stop level, right? And what actually makes condition 23 more
Would your
burdensome-
analysis be different if the standard was probable cause? So in other words, if a probation officer probable cause sent to the workplace?
I don't think so, Judge. I think the reason why 23 is more burdensome is not so much the search condition itself, but the warning he has to give to potential employers.
I think it seems to me that condition number 23 is less burdensome and it's more protective because there is a threshold that the probation officer needs to meet to enter the workplace.
I think where the burden comes in is in the job interview process when he has to explain to any potential employer that if you hire me, my conditions require me to warn you that your entire workplace could be searched if they suspect me of anything. I mean, most employers aren't going to want to hire someone who's going to bring that kind of condition with them. I see I'm already in my rebuttal time, but the last point I wanted to make is why I think 3583E2 is not an adequate substitute for this. I realize that we can always, or not we, because I won't be representing him anymore after this appeal, but hypothetically, he could file like a pro se motion to modify the conditions later. However, he's not going to have counsel in the future. And when he actually gets released, if they're re-reviewing his conditions, we have no idea if Judge Tharp's going to be on the bench in 2044. He might be, he might not be. And what we want to hammer down is the intent of Judge Tharp on these conditions, which is why if it's ambiguous, I'd recommend instead a remand similar to Zepeda for clarification. Thank you.
Thank you, Mr. Roy. Mr. Berry.
Thank you, Your Honor. May it please the court. My name is Albert Berry, and I represent the appellee of the United States in this matter. Thank you for allowing me to appear via video. I want to start with Mr. Robinson. And in regards to Mr. Robinson, I want to make clear that the district court properly admitted Anise Robinson's prior grand jury testimony as evidence in that case. This case is in line with what this court decided in United States versus Schaefer's. When a witness has a memory loss under Rule 801 D1A, if the person testified in the grand jury and it's inconsistent with that memory loss, the government is allowed to enter that grand jury statement into evidence as substantive evidence. And that's exactly what happened here. The appellant raises issues about feigned versus genuine memory loss, and that's not something that's borne out in the cases. In fact, in United States versus Gaggio, the court stated that that's not relevant. In fact, the court stated that cases should not determine or distinguish between the two. It said that, we shouldn't worry about whether the witnesses are turncoat or not. It's simply whether the witness has a memory loss and whether that's inconsistent with their prior statement. And that's what happened here.
Mr. Berry, what are the limits to what you're arguing? You seem to be saying as long as the person is physically present, that's sufficient. I know we had a lot more than that here. She was able to answer various questions, but in terms of limiting principles, where are they in the government's argument?
Thank you, Your Honor. The limits and principles are exactly what we stated in Schaefer's. You can't have an individual that sits there and stares and does not answer any questions. A person who claims a privilege, those things would be out of bounds for inconsistent statements. However, here, as Your Honor stated, there is a lot more that's taken place here, and there was an opportunity for cross-examination in this case. The witness was allowed, the defense, was allowed to take advantage of some realistic weapons to undermine the credibility of Anise Robinson, and in fact did so when they cross-examined her about her bias. As Your Honor stated earlier, there were, and as laid out in the brief, there are many instances of which Anise Robinson remembered certain things about her past, and those biases were brought out in her testimony. I want to state also that we believe that it was proper in the way it was admitted. However, even if the court finds that it was not, we believe that there's harmless error here. We do believe that the evidence in the case was sufficient enough, even without Anise Robinson, to show that the defendant was guilty beyond a reasonable doubt.
How can we say that Anise's testimony didn't contribute to the verdict?
Yes, Your Honor. What we have here is a series of events. It's not just the identification of the individual that committed the murder that would give you a violent crime in aid of racketeering murder. This isn't just a simple murder. It's a murder that has a bunch of different ties to it and a bunch of different elements. We do have, in defense counsel, appellant argues about Sierra Robinson. What he fails to mention is that Sierra Robinson was on direct, cross, and redirect examination. All we talk about here is the cross-examination. On direct examination, Sierra Robinson identified her cousin, whom she grew up with, whom she lived in a house with, as the individual that was in the video and in the still pictures. On cross-examination, defense counsel asked a question about one of the pictures. In that cross-examination, Sierra Robinson stated that she could not identify, however, from that picture, however, there was a paper form of the picture where it was clearer and she would identify. Defense counsel took it a step forward and went to the next exhibit and stated, and you can't identify here either. And she said, I would disagree with you. So Sierra Robinson did disagree with defense counsel in not being able to identify an individual in one of the photos, and said that she could clearly identify the individual as her cousin, Pierre Robinson. Though she did admit to a bias, she stated on redirect examination that she was clear that that individual in the video and in those photos was Pierre Robinson. Now, if you take this in conjunction with the other evidence in the case, 40 minutes prior to the murder that took place in the store, there is a posting, and I think it's a Government Exhibit 223. It's a posting that Pierre Robinson put online. And in that posting, which has a lot of words that are slang but were interpreted during the trial, Pierre Robinson basically promised to get revenge for the murder of a slain fellow gang member, Mr. Chris Spraggins, 40 minutes before the murder. You take that through line and you go to Exhibit 102, which is the compilation of the murder. An individual comes in, covers his face as he comes in the front door, walks to the back of the store, turns around and comes back towards the front of the store with his face uncovered. As the victim passes by of Mr. Robinson, the defendant covers his face again, goes outside, comes back in, pulls out a revolver, and fires at the victim. This is all relevant because later on, Mr. Robinson posts a video online with Mr. Swanson, who was the cooperator, where he waves a revolver in the camera and states, "No face, no case." That was explained to the jury as, and a through line can be brought there, that an individual who's pointing a revolver in the camera, and the murder was committed with a revolver, no face, no case. He didn't have a face that was in the camera. Additionally, Mr. Robinson had a posting, which was Government Exhibit 105 and 105_1. In that video, Mr. Robinson is back in front of the Eberhard store on 79th and Eberhard, talking about the murder that he committed. He's actually bragging, says something like Mac sauce and disparaging the individual who was murdered. And underneath, which is 105_1, the caption is #backdown memory lane, 3 target emojis, and a no smoking emoji. And that was explained to the jury also. You take that through line, and then you have the identification of Sierra Robinson. You have the identification of Mr. Swanson, who's a fellow gang member, who the jury saw the defendant with pictures throughout the trial, social media evidence, and saw also video of the two together. Mr. Swanson stating that he, Mr. Robinson, confessed to him in a barbershop, where the counsel says that he didn't name the barbershop. However, he named the owner of the barbershop, and he wasn't specifically pushed to ask to name all the individuals that were there. All of that taken together, put in front of a jury, shows an identification. If you take out Anise Robinson, there's an identification by 2 individuals who know him well. And then there's also all the other evidence that's necessary to have a violent crime and aid or racketeering murder. This is the government's position that therefore it's a harmless error. As we step forward, as Your Honor stated, the ineffective assistance of counsel claim is a high standard to meet, and I don't think that the appellant meets it here. With regards to
Mr. Berry, while on ineffective assistance of counsel claims, I think all other circuits besides ours really decline to reach these claims on direct review, where the record on appeal isn't sufficient to address them. I know this may not be the case to take that issue up, but is that something this court should consider?
I believe so, Your Honor. The record here is not complete. There's a lot of insinuations as to what defense counsel may have done, should have done, what's the reasoning behind their strategy. And in the government's position in trying these cases a lot, the strategy isn't always to combat just the murder, because that's only one of the elements of it. If counsel feel that the murder is actually proven, there are other avenues. You have to find that there's an enterprise, and that was something that was argued here throughout the entire case. Whether there was an actual enterprise, whether the defendant was a part of that enterprise, that was argued extensively throughout the case. Whether the enterprise engaged in racketeering acts, that was a big section of the cross-examination of Mr. Swanson. Whether that affected interstate commerce, that's also a section that defense counsel argued against. And we're just left here to kind of imagine what the strategy would be, because there was no hearing about what it was. So I don't believe that the court should address it. However, even if the court decides to address it, I don't think it reaches the level of plain error, which is the standard here.
Why shouldn't the standard be de novo, given that we're dealing with the confrontation clause? And there's a little bit of inconsistency in our case law on what the particular standard is.
It appears, Your Honor, and I think if you're talking about the Shukri case that was cited by defendant, where it stated that it should be a de novo review, I think the inconsistency there is that case cites a case Stoya, and Stoya is based off of a 2255 review. Stoya in and of itself cites a case called Bond, which is also based off of a 2255 review. And that's not the case that we have here. Our case law, I would say Cates is what controls. And Cates says that the proceedings in the district court determine the guilt or innocence. It's unlikely to show conclusively whether the lawyer's representation was inadequate and had an effect on an outcome. So there has to be it's our position that there should be an evidentiary hearing below, raised through 2255 in order for the case, or in order for this court to determine it de novo. I want to just touch a bit on Mr. Swanson. Your Honor, during the sentencing of Mr. Swanson, defense counsel was interrupted a bit. However, defense counsel did state in there that he had one issue, and there was one issue that was covered by Judge Stark when he actually went ahead and had the written order. So the one issue was the defendant's discretionary condition 16, which is that the probation officer can visit the defendant at any time. And as Judge Lee stated, that's the least restrictive one. That's the one that where he can come at any time and visit. And it's our belief that that's what defense counsel was speaking about in that case. However, even if there was some ambiguity, we don't believe that there was. Case law says that the written order would clarify that ambiguity. And in this case, Judge Stark clarified that ambiguity by only unchecking discretionary condition 16 and not discretionary condition 23. I have a little bit more time, but thank you. If there are no questions, I would just ask that you uphold the lower court's decision on the guilty verdict. Thank you.
Thank you, Mr. Perry. Mr. Rayfield, we'll give you your 2 minutes back since we asked you a lot of questions.
Thank you, Nora. So as for the cases that have been decided by this court, I don't think this court has ever faced the combination of facts that are present here, where a witness genuinely has no memory of the defendant or the prior identification or the
Can I ask what you base the genuinely on? Because as I read the transcript, she remembers some things, right? So what can be the standard for a judge to gauge whether something's genuine or not?
Right, so she testified that she remembered, that she couldn't remember a lot, but that she did remember certain things. And there was no dispute in the district court that her memory loss was genuine. The burden of proof was on the government to establish an exception under the Confrontation Clause. So if I'm right about the law, if I'm right that there's a distinction between feigned and genuine memory loss, the government had the burden to prove that she was feigning her memory loss, and the district court would have had to make a finding on that point. But because you have both genuine and what we're referring to as in shorthand as total memory loss, this case is just like the Mississippi Supreme Court's decision in Goforth, which applied this court's cases and found a Confrontation Clause violation. I just want to address the government's point about a witness who refuses to answer all questions, because that was, I think, one of your questions was, where do you draw the line here? Well, we would say that actually the situation where a witness comes onto the stand and pleads the fifth, from the perspective of the defendant, is actually better than the situation we had here where a witness genuinely has no memory of the relevant events. At least in the case of a witness who's pleading the fifth, it becomes obvious that the witness has a self-interested reason for declining to testify. With Anise, the jury had absolutely no reason to fault her testimony, her identification in any way, because of the fact that she couldn't remember it. So this is the worst of all possible worlds from the perspective of the Confrontation Clause.
Okay, thank you, Mr. Rayfield. I understand you're appointed. You and your firm took this for appointment. Thank you very much for your service to the court and for your strong advocacy on behalf of your client. Thanks to all counsel, and the court will take the case under advisement.
Thank you.
The next case for oral argument this morning is 24-2066, Dulworth versus Experian et al. Morning, Mr. Rapp.
May it please the court, Michael Rapp on behalf of the Mr. and Mrs. Craig and Brianna Dulworth, appellants in this case. There are 4 questions to be considered on appeal. Number 1, the plaintiffs had substantial evidence of both reputational and emotional damage and distress injuries. Did the district court err in its conclusions about the nature and the scope of the plaintiff's injuries and the damage that flowed from them? Number 2, did the district court err when it concluded the plaintiff's allegations and of inaccuracy pertained only to the questions of a legal duty? And 3, plaintiff's evidence of the undisputed facts that created a factual question about the reasonableness of both the defendant's procedures for reporting and investigating the Ally loan. For the purposes of both EB and I, 1681 EB and 1681 I, the reasonableness of the CRA's procedures is generally a question of fact for the jury. So did the district court err by failing to recognize those questions? And lastly, a plaintiff can prove the CRA willfully violated the FCRA by showing that it acted recklessly or knowingly or deliberately when it violated the statute. So did the district court err in concluding the plaintiff could not prove any willful violations? Ultimately, in this case, I would start with the fact that both the CRAs in their joint motion for summary judgment have very different situations. They were not in the same position. One decided through its own internal policies to not respond to the dispute at all. There was no record that they had of even receiving it, despite the Postal Service having green cards showing that they were received and stamped and received by Experian, otherwise disposed of. And Equifax did actually conduct the investigations and came to a conclusion that they were going to believe exactly what they got from Ally, relying upon the reasonable, reliable furnisher standard. I think that this court in Chaitoff probably answered this case most succinctly. Is a contract a legal question or is it a factual question? I do not believe the TPP in Chaitoff is significantly different than the existence of a reaffirmation agreement inside of a bankruptcy. Once they were presented, as in Chaitoff, with inside the dispute of the existence of that contract, why did they not dig any deeper than looking at their computer screens and asking the furnisher of the information for a thumbs up or a thumbs down?
Isn't the question here more than just the existence of the reaffirmation agreement? Isn't the question really the validity of it?
I don't believe so, Your Honor, and for two reasons. Number one...
Because why, in answering in those two reasons, please, why the existence of the reaffirmation agreement on the bankruptcy docket would let them know anything? Because there are conditions to it. There's nothing from the court saying this is in existence, that they've complied with it. There's nothing at the end of it saying reaffirmation's still in place. So answer that if you would, please.
I appreciate the question, Your Honor. I think that that is salient, but also analogous to every contract question. Why would the existence of any contract ever be evidence enough of something? There's always compliance issues with any type of contract. And they have two pieces here. Number one, Ally is telling them that they are making these payments. That information is being submitted to each of the CRAs. That's number one. And that was ignored or suppressed by both of them. Number two, the validity of the agreement was never brought into question until litigation commenced. It has not been Ally's position that the agreement was invalid. Their own testimony of their 30B6 witness said that in their computer systems it shows as valid, and they never treated it otherwise. They may have misreported it to the CRAs, but that is what the point of the investigation is. And maybe thirdly, and I would pose a different question, why would Ally's testimony be inherently more reliable than a court record? Don't we give full faith and credit to competent jurisdictions? If there was nothing from the court to say that it was invalid, that they had disregarded it, isn't it an adjudicated matter? Why would...
But it's not an adjudicated matter, right? I mean, that's I think the Loesch case is kind of an interesting comparison, because there, the debtor actually obtained a court order with regard to the validity of the reaffirmation agreement, or the agreement at issue there, whereas here, the parties, signed it, met some of the procedural elements, and then filed it. Isn't that different from a court actually, as Judge St. Eve noted, kind of blessing it and approving it as valid?
The only question I would pose in my answer to that is, when is it enough? What more would this particular debtor have to have done? Have simply said to them, here's my agreement, I complied with it fully and completely. And it was not taken at any point in time by the CRAs as valid. They decided internally, based upon their own procedures, that they were going to believe the rote reporting, the automated computer dispute verification form from Ally that was transmitted back to them as valid. So they decided in that moment to ignore the documents in front of them and not query any deeper than their own computer screens and decide that information was invalid. It is not Ally's position. It seems
to me that they were put in this position where they had to choose one or the other, right? I mean, they went back to Ally by submitting their query. Ally came back and said the loan was discharged, so they have that. And then they have statements from your client saying that the Ally loan was reaffirmed. And so at that point, they're in a position where they have to decide. And isn't that the question here, it seems to me, is that a factual determination or more of a legal one? And, I guess it seems like that's a dispute that a court is better handled or able to handle than, say, a CRA.
I can appreciate the statement. The question, though, is when would you not have to go back to a court to look at a document to say, is this still valid? That's number one. Number two is the statute actually already gives them a remedy, which is under I, all you have to do, if you have conflicting information that you cannot verify, you suppress it. They chose to do otherwise. They chose to believe Ally and ignore the court records.
But only
and I don't
if
understand why the court records are less valuable
Only if it's factual. If it's a legal question, you don't have to do anything else. And our case law makes that very clear.
Absolutely. So why is a TPP less of a fact or more of a fact than the contract between the debtors in this case, the debtor and ally in this case, than it would have been between Ocwen and Chaitov? I don't see the difference. In fact, the only thing that I see different between those two is that there was a court overseeing this contract, and at no point in time did they render it invalid. It was not until this litigation that was the question of validity was even injected. It's still not.
What do you make of the difference in that the TPP in Chaitov specifically said that the furnisher or the creditor would provide the information of the TPP to the CRA? And so from the face of the document, the CRA can look at it and say, okay, well, I guess the creditor agreed to give us notice and the creditor didn't.
I agree with that, but that's a different analysis. What we're looking at there is, did they even know that such agreement existed otherwise? And they were provided with it in the dispute, both in this case and in the Chaitov case. So they had knowledge of it. They actually had knowledge of the payments that were being made. So they have now conflicting information that is not just a standard run-of-the-mill situation. And they chose to disregard it and concluded that this must not be valid or it's not something that they have to look at. If that's the case, then the reporting of bankruptcy, this is not unusual. This is not so bizarre and outlandish that this doesn't happen regularly. They regularly report bankruptcy information. They were very narrowly tailored to say in the dispute that my problem is not that I didn't declare bankruptcy or this wasn't included. It was very clearly included and held aside by this contract. And they chose not to believe that and continue to report it as discharge, denying them the good payment history and giving them the double damage of having a discharge but not having the good payment history, which flows to the next question, which is damages. The damages in this case were disregarded by the trial court in two ways. One, the reputational harm of the loss of the credit history, which did make getting a new loan more complicated and more expensive. But the second piece was ignoring the emotional distress injuries. And I believe that in this case, McCraig versus Wells Fargo, it's actually in the Fifth Circuit case in 2015, discussed husband and wife supporting each other's damages. On the face of it alone, that should be enough. There was physical manifestations.
But we've been very clear that just broad conclusory statements about emotional damages are not sufficient.
Absolutely, and I believe that we met that standard.
What's your evidence beyond just statements that they were frustrated or aggravated? And what's the evidence to support?
The higher blood pressure. There was manifestations that were physical that were described by each other and referenced in other witnesses and to include her employer.
But how do you connect the higher blood pressure to this case and to what happened here as opposed to the bankruptcy? Because the testimony in the district court was that, it might be connected to what happened here. And the testimony and what the court found was that it was more in relation and as a general result of the bankruptcy stress.
I appreciate that question, Your Honor. Actually, that would be a weighing of the evidence by the trial court.
No, it wasn't a weighing. It was saying there's no support.
I believe that the testimony was very clear by both the husband and wife that this was a problem, that it stemmed from this. Whether or not there were other factors in their life that were complicated, or also things for a jury to weigh in calculating the damages. Concluding that
you're into your rebuttal time if you want to save some.
I would be happy to, but I also want to answer all of your questions. But I believe that just as a summation to this, it is also important to bring up the fact that Experian decided, based upon their own policies, to do no investigation whatsoever. That's never been in dispute. And that Equifax came to a conclusion where they just purely parroted it. I don't think that Experian should be able to rely upon an envelope that they never opened. Or if they did, they judged the content of it by the character of the envelope itself. Thank you very much. We believe you should be remanded back. Okay.
Could I ask you a question about reputational damage? So I think the denial letters don't mention Experian, and so I think you're relying upon the hard inquiries that were made that are set forth in the documents, right? And
Yes and no, Your Honor.
Okay. I guess my question is, and I think you make a statement that it's reasonable to infer that, for example, Citibank, who made a hard inquiry, found the statement and the omission of the other statement to be defamatory. And I guess my question to you is, why is that a reasonable assumption?
It's also incomplete, which is also required by the statute. It did not include the valid, good payment history that they had earned by making their payments. They're not in the same position as a bankruptcy debtor who paid nothing to anyone.
Okay, but we're focusing on defamation, right, and the reputational harm.
Absolutely.
And so why is it a reasonable inference to make that Citibank would have treated, would have had a better credit perspective of your clients if, rather than saying that the loan was discharged, in other words, clean slate, if it said, you know what, this loan actually survived and it's still alive and there is kind of a payment history?
Because when you don't pay your debts, that is one calculation of risk. When you choose to pay your debts in addition to it, that is a different calculation of risk. So showing that they continue to make payments would make them a better credit risk than not. And that is a reasonable inference for a jury to weigh.
Isn't there also a risk that, given the fact that that loan is still out there, isn't that a credit risk as opposed to the loan being discharged?
I believe that what you're talking about right now is weighing the evidence about the damages and about whether or not the reputational harm.
Your reasonable inference about how a jury can make such a determination without any sort of, let's say, expert testimony or some other indication of what it all means.
Well, the expert testimony in our case did talk about from Evan Hendricks, discussed the fact of how credit scores are calculated. You can't discuss damages, but you can look at the reasonableness of those two things. And a person who's paying their debts versus a person who did not pay debts at all, one has a credit history and one does not. A complete break versus somebody who still has a credit score. And if you look at the denial letter for one, it does say that lack of credit history was a factor. If they had included the full credit history, it would have improved their credit situation. That is one reasonable inference. The second thing, though, is when it comes to Experian, their credit reports were accessed by other people in addition to it. But that's a different standard regardless. But thank you very much.
Thank you.
Mr. Johnson.
Good morning, Your Honors. May it please the Court. Jeff Johnson on behalf of Experian. Just to start with my colleague's comments about injuries in this case, let's start with the first one that he led with, which was emotional damages. I think even in this morning's presentation, I haven't heard a challenge to the to the district court's key conclusion to start with, that there's no evidence that traces any of it to the actions of Experian particularly. Of course it's stressful to go through bankruptcy. Of course it's stressful to have a reporting problem with Ally, but the testimony on pages 226 and 227 of the appendix is quite clear that she only testified about the overall sort of situation, and even then, only in terms that this court has repeatedly said don't qualify as sufficient evidence of damages. I find it noteworthy that my colleague's primary citation on this point was to the Fifth Circuit and not to this circuit. And as we said in our brief, the circuit's case law is very strict and expressly says that it's strict on that point. So I think that that's enough to solve the injury of emotional damages. As for the reputational injury, I think, Your Honor, you hit on the key question: what do we do with this hard inquiries that are present on here? And again, I think this court's decision in Freeman is very clear that that's just not enough. There were hard inquiries in Freeman. The decision says, the record also contains the record indicates that Quicken Loans and Chase Card requested her credit report from TransUnion, and that those reports contained Ocwen's inaccurate reporting. And this court said that wasn't enough to prove that the person in question understood the defamatory significance of the statements at issue. I also think it's very telling, as Your Honor sort of indicated, that what we don't have here as to Experian, we have a number of denials of credit that say, we pulled the credit, we lowered the score, we denied you this application because of TransUnion's reporting or something like that. There's nothing like that for Experian, especially for the loan report that comes after they raise their dispute.
I think there was evidence, though, to support that Experian actually published some of the credit reports to third parties. The district court said there wasn't, but I think there was some evidence that was overlooked.
Their inside plaintiff's dispute contains copies of the report that show that certain individuals made hard inquiries. That isn't enough under Freeman. It's not mere publication. It's publication where someone understands the defamatory significance.
What about if information is published that everyone would agree would be negative? So in other words, say that there was a default of a loan when the loan was actually not defaulted. In that context, couldn't a jury reasonably infer that that would be negative to anyone in the industry?
I think it would have to be a pretty high bar to reach that level. So for instance, I think TransUnion, the Supreme Court case, if someone calls you a terrorist on your credit report, that's something that the sort of pain of that comes instantly to mind. Everyone sees, everyone understands. I think in the credit context, it's difficult because you need to remember, even for hard inquiries, one, there's a statutory obligation to report if you relied on that in making a decision. So we're going to have evidence of what you thought about, what you knew about. It's also here, I mean, you can imagine that the Best Buy computers, for instance, or the Best Buy checkers say, okay, this is your fourth bankruptcy. We don't need to look any further into whether we're going to extend
to your first point, that's something I hadn't focused on. So you were saying if the hard inquiries was part of some decision, some credit decision, that those people had to provide the appellants with notice.
Right, and that's why we have in the record so many copies of notes that say, this is the teacher's bank, you applied to get credit for a car, and we're denying you, and that was based in part on these reasons. And we don't have a single record like that in this record as to Experian. And so I think that sort of suffices to show why there's no standing in this case, even if the district court, didn't quite put it in the right bucket.
I think Freeman involved a loan listed as delinquent, and we found that wasn't sufficient to establish the reputational damages, or that the credit reporting agency understood the defamatory nature of that alone.
Right,
so I guess where's the line between terrorist in TransUnion and delinquent loan?
That's fair. I mean, I have to say, I feel like we're on the same sideline as Freeman must be. Of course, when Chase Card and Quicken Loans are asking for a report about the Freeman's credit, of course a delinquent loan is going to be on there. Here, as we can talk about briefly, or as my colleague will discuss probably in more detail, we're talking about a legal question about whether there was a reaffirmation agreement that was validly entered, and then some subsequent payments that only matter if they were made pursuant to that affirmation agreement. And so I think this case is a fortiori from Freeman. If this court was correct that there was no standing in Freeman, then there's no standing here.
Mr. Johnson, if there's no standing here, does this get remanded back to the state court?
The statute does say that you should remand after that happens. It does say shall. That statute is not jurisdictional in the sense that if you don't ask for that remedy in your opening brief on appeal, I think you can waive that objection. What we have here is nothing in the opening brief about a remand being the right order of action, and then a line in the reply brief about that. And so I don't think that it's been sort of correctly processed here. I will note also that remand in this case is kind of going to, this court will decide in the Equifax half of this case, the merits of the legal inaccuracy thing. So I think it will be fairly clear. The writing will be on the wall for that point. And then just very briefly on the legal versus factual point. Everything this court said in Schulenbat about what makes something legal versus factual applies all the more strongly here. To know whether or not those payments that were being made were pursuant to an obligation or purely voluntary, the CRAs had to know whether they were made pursuant to a valid agreement to reaffirm or not. Knowing whether that's valid or not requires the exercise of legal judgment, and unlike in this court's decision in Chadoff, or unlike in the 11th Circuit's decision in Loesch, there was no document that liquidated that legal question into a factual point. There was nothing that said this has been adjudicated to be invalid one way or the other. And so I think it follows pretty straightforwardly from Schulenbeck. Thank you, Your Honor.
Thank you, Mr. Johnson. Mr. Barton. Good morning.
Good morning. May it please the court, Eric Barton for Equifax. I wanted to just dive right into the legal versus factual issue, and I believe appellant's counsel used the phrase, when is enough enough? You know, when is enough for a consumer to show that they complied with an agreement? And to be clear, just because a case involves a legal contract doesn't mean it automatically is therefore a legal argument that can never be resolved by a credit reporting agency. So we're not, and the case law is clear on that, because in the situation, we have cases that involve contracts, like the Chadoff case, where the court held, no, it did involve a contract, a legal contract, but it's still considered a factual dispute. And I believe the court's reasoning is sound, because in that case, as I believe the court is aware, in that case, sure, there was a legal contract. There was also proof provided by the consumer that they timely made the payments required by that legal contract, and proof in the form of a letter from the furnisher that they received those payments. So you put the three together, you got a contract, you got proof of payments, and you got an acknowledgement of timely payments. And the court was clear, in that situation, you don't get a get-out-of-jail-free card to say, well, there was a contract, so therefore it's a legal dispute. That is not the situation we have here. The situation we have here is we have the appellants, the plaintiffs point to a reaffirmation agreement and want to say, well, that's it. There's a reaffirmation agreement, and therefore Equifax, you're wrong in your reporting. But I believe, as the court highlighted with some of its questions, there's so much more that goes into it than just the existence of a reaffirmation agreement on a bankruptcy docket. And as the district court properly noted, simply examining the bankruptcy docket wouldn't show whether or not the dull worse. Was the agreement properly signed? Was it a legally valid agreement? Did they comply with the terms of that agreement over the set period of time? Whether that Dulworth ever rescinded that agreement. We simply don't know. In order to do that, you'd have to make a legal determination. And, and we do not have, like we have in the Chadoff case, we do not have a situation where the Dulworths in their disputes to Equifax or Experian not only provided the agreement, but then said, look, here's proof of payment, and here's an acknowledgement by the furnisher that they received the payments, or that the reaffirmation agreement is in effect. Obviously,
Allie's ACDV report lists the loan at issue here as discharged in bankruptcy but current. Why wouldn't that be enough to put you on notice of an inaccuracy and a factual inaccuracy?
I believe because you could argue, and plaintiffs' counsels argue, that is inherently conflicting statements. Respectfully, I don't believe that's inherently contradictory. There are plenty of situations where you can have situations where someone, such as perhaps here, goes into bankruptcy, has a vehicle that they're making payments on that's included in the bankruptcy, but perhaps wants to starve off the repossession of their vehicle. Mrs. Dulworth, who had this vehicle, said that she was using this to get to and from work. So maybe they make payments to the lender to say, so they don't get their vehicle repossessed. The lender stands down on its right to legally repossess it. They make the payments technically quote unquote voluntary payments for that. And so, yes, the trade line at issue is included in bankruptcy, but it still, they list it as current. In this case, tellingly, the furnisher did not provide monthly payments because it was included in bankruptcy. It wouldn't, if we had a situation perhaps where they had a payment history where it was showing payments being made, perhaps that tilts the needle a bit further. But we don't have that situation here. We had a reliable furnisher. There's no evidence that Ally is an unreliable furnisher that was repeatedly stating that this was a trade line that was included in bankruptcy. We had no information provided by the consumers that would cause Equifax to unilaterally override the reporting by a trusted furnisher, and therefore this is clearly a legal dispute. You would have to resolve a legal dispute, which this court, all the cases set forth in the briefing, highlight.
Counsel, if the Dulworths had provided proof of payment, then what? And because the duty here is to reinvestigate if there's a question.
I could argue perhaps again the needle analogy. It may move the needle a bit further, but at the end of the day, whether they were actually, if they said here's a bank account and here's us making payments, they very well could be making payments on a car loan.
But isn't that where the duty to investigate comes in for Equifax?
If they had done that, perhaps it would. Well, respectfully, I don't believe that takes us out of whether it's a legal analysis or not, because at the end of the day, whether there were payments being made or not payments being made by the Dulworths on this trade line, the issue is, was there an enforceable reaffirmation agreement that the Dulworths complied with?
But in bankruptcies, my understanding is oftentimes there's no court order validating a reaffirmation agreement. And so does this mean that Equifax is always off the hook unless there's a court order?
I don't believe we're always off the hook, because this is a situation that the Dulworths were aware of this for quite some time, and if we were dealing with a situation, which we are not, where they had gone to the bankruptcy court and gotten clarity and provided that additional information to Equifax, perhaps then we'd be in a different situation. But we have to look at purely at the information that Equifax had at its that was provided to it by the Dulworths and what was available to it by reviewing the bankruptcy docket, and as well as what Ally, a Relied Furnisher, was telling it. And there was no way the middleman of Equifax or Experian could make the legal determination about the enforceability of that reaffirmation agreement. Thank you.
Thank you, Mr. Barton. Mr. Rapp, I think your time was up, but we'll give you 1 minute.
I appreciate that, Your Honor. It's very gracious. I would start off with the fact that the Chidoff's case, the thrust of it was also legal versus factual. They stated then that was a legal versus factual argument, and this court decided differently. Mr. Barton brought up 3 steps. The proof of the payment, that the fact that there wasn't a dispute about the contract existed or its validity. I think that and there was a contract, there was proof of payments, and there wasn't a dispute to the validity. In this case, it's identical to that, because we had the contract, we had proof of payments that was distributed to the CRAs by Ally. It was in the normal monthly reporting that they would get in their tapes. And number 3, which is it was never disputed by Ally that this was a valid agreement. This is a complete injection throughout the litigation process. It didn't exist before that. Lastly, when we're just talking about the questions that need to be asked or whether or not the Dulworths could have said more, I think at no point in time did Equifax ever ask Ally, is this reaffirmation agreement valid? They never posed any questions whatsoever. They looked at the computer screen, they looked at the reporting, they said, verify everything, and they said, thumbs up, and that was the end of their investigation. They probed no further, despite the fact they had this payment history. So again, Ally is reasonable as a matter of law, is what this court has decided, yet the bankruptcy court's documents are not reasonable as a matter of law, period. We think that that's a problem. Thank you very
Mr.
much.
Rapp. Thanks to both sides. The court will take the case under advisement. The next case for oral argument this morning is 21-2737, PAV versus Bondi. Good morning.
Good morning, Your Honor. May it please the court. There are several reasons why this court should remand. Today I'd like to start with the board's failure to consider the issue of past persecution. The board found, and I'm quoting, "There is no dispute that the applicant has not experienced past persecution." The board was incorrect. There was a very clear dispute about past persecution. The immigration judge addressed the issue and decided the issue in his decision, and my client argued the issue in his appeal brief to the board. In fact, 2 full paragraphs of his brief addressed the issue, and he didn't just mention past persecution 6 times, but he cited the Fifth Circuit's directly on-point decision in Morales-Lopez versus Garland. He tied the law to the facts of his case, and he argued, and I'm quoting again from these paragraphs, "The IJ dismissed the idea of past persecution, failed to meaningfully consider all the relevant evidence, and could have determined that my client suffered past persecution." And I'll direct the court to appendix pages 11 and 16 for those paragraphs. The question here is whether these paragraphs lacked even the semblance of an argument, or whether they were sufficient to put the board on notice that my client sought to challenge the immigration judge's denial of his claims of past persecution. And that's this court's decision in Hamdan versus Mukasey. And we submit the arguments were more than sufficient to put the board on notice, and that his brief speaks for itself. So the next question is, why does any of this matter? Why does it matter that the board did not address the issue of past persecution? It matters because if the board had considered the issue, it very well could have disagreed with the immigration judge. The board, under this court's case law...
Why didn't the board decide it? Why isn't it clear that the board actually decided it? Because it went on to say, after it said there's no evidence that the applicant himself suffered past persecution, and then went on to explain it doesn't appear that the death of his brother was targeted at the applicant or that the family members' incidents were targeted. It sounds like the board's statement was clarified by addressing the evidence. So the board did address it.
Your Honor, that's not the way I read the decision. What the board said was that there's no dispute, and then he went on to address immediately, I believe, future persecution, to address certain facts as they relate to the risk of a future threat to life or freedom. And
the board specifically said there's no evidence the applicant himself suffered past persecution. That sounds like past persecution. And then went on to say no evidence of a link between family members and PAV himself, which would be the relevant piece for past persecution.
Your Honor, frankly, I'm not sure which page of the decision you're referring to. I'm looking at the short appendix, page 4, and he simply says, the board simply says there's no dispute. But even if it addressed the dispute in the way Your Honor is describing, that is not sufficient. That's certainly not sufficient because the board was obligated under the court's case law, just as the immigration judge was, to consider the totality of the circumstances and to determine whether the harm suffered by family members in combination with other factors may constitute past persecution of the applicant. That's Chen versus Holder. And so if the board addressed the issue by simply saying that there's no dispute he personally experienced harm, that's not the right inquiry, and it's also incorrect. Which brings me to the immigration judge's analysis. The immigration judge considered only 2 events in his past persecution analysis. The first was, as the immigration judge described it, somebody came up to his table at a restaurant and demanded that he immediately leave town. I'd just like to clarify, it was 4 or 5 armed members of the cartel who pointed their guns at him, flipped over his table, and my client fled immediately, first the restaurant and then the country. And the immigration judge dismissed this as, quote, not past persecution, and that's it. No further analysis whatsoever. And the second event that the immigration judge considered was the murder of my client's brother. And with respect to that event, the immigration judge said it does not appear to be targeted at the applicant, and again, that's it. But under Chen versus Holder, it does not matter if the family is harmed in order to target the applicant. And aside from those two facts, there are many key facts that the immigration judge did not consider at all in his past persecution analysis. One of these was the credible threats to my client that were made in phone calls and messages to his parents. I'll direct the court to appendix page 229, and that's where my client explained that they threatened to harm me because I was my parents' son, because the cartel was threatening the entire family. They were also burglarizing and ransacking their home. And I'll also make clear, this might not be clear in the briefing, and frankly, it's not 100% clear in the record, but my reading of the record is that these calls happened while he was still in Mexico, as long ago as 1999, and continued all the way up through at least the death of his brother in 2018. So we're talking about a 20-year, at least, a stretch of time where the family's being threatened with harm to themselves and to their children. And the immigration judge did not consider it for past persecution at all, and of course neither
What's
did
your
the court.
strongest argument that the threats against the family members had anything to do with PAV? Oh.
Well, the evidence is that they were directed at PAV. And let me put it this way, Your Honor. There are several cases that make clear the threats can be aimed at the applicant without being made to the applicant, and that's what we have here. Not only was he directly threatened in the restaurant by armed members of the cartel, and on that point I'd refer to the WGA case where the applicant was threatened with the firearm, and that alone was past persecution. But he was also threatened through the phone calls to his parents. And then, to Your Honor's question, I want to make clear it's not any one event that we're contending amounted to past persecution. And that wasn't the evidence. The evidence was Dr. Mead's testimony, who said it's a combination of all of these things. It's the family members being killed, the family members being kidnapped, extorted, threatened. It's the combination that led him to believe my client would be targeted, and that too went unaddressed by the immigration judge and by the board in the past persecution analysis. And the key point here is that the court does not need to decide, it shouldn't decide, the merits of the issue. It should not decide that the immigration judge was right or wrong in how it weighed this evidence or what it considered. What it should do is remand so that the board can address the issue in the first instance and address these key facts that it never addressed in its decisions below. Because my client was entitled to meaningful review from the board, and I frankly just do not think he got that with respect to the past persecution issue. And I'll note the board's failure infected its entire analysis because a finding of past persecution would have shifted burdens. It would have created a presumption of future persecution. It would have shifted the burden to the government with respect to the question of relocation, and the entire analysis would have been different. And so, for all those reasons, the court should remand to the agency and to the board to consider this issue in light of the court's guidance from Chen versus Holder. Second issue relates to the mixed motives analysis, the nexus analysis. And the immigration judge here wrote that the core of his ruling was his determination that no one is targeting the applicant's family other than extorting them. That sounds to me like the agency found that the family was being targeted because it was being extorted. The cartels were extorting the family. But because it was extortion, it wasn't persecution. And that was error, because an applicant can't qualify for withholding of removal if his persecutors had one or more motive.
Why doesn't that reflect the immigration judge's finding that the family was being targeted for extortion reasons, not because of a link to PAV?
Well, Your Honor,
because they had, under their home, they had resources, and that they were targeting them for those reasons, again, not linked to PAV, which is what the nexus requires.
Your Honor, Nexus requires that they be motivated in part by one of the factors specified in the Act, which includes membership in a particular social group, including family membership. But the immigration judge never asked that question. It never asked whether that extortion that it evidently found was partly motivated by family membership. It never considered the possibility that extortion can be committed by persecution or through persecution. And on that point, the court's decision in Mohadeen versus Gonzalez, the family was, I believe the family was wealthy. They were being targeted for money, for extortion, but the family was being targeted. And the court said it doesn't matter that their end goal might be money. They were targeting the family, and that's similar to the case we have here. And the government's, in their brief, their only response was that the immigration judge just never reached the issue. In fact, I think the government agrees that if the court thinks it did reach the issue, remand would be appropriate, and if it erred on the issue. But with respect to the government, I think that is incorrect, that the immigration judge never reached the issue, because throughout its opinion, it talks about intent, it talks about the reasons for the cartel's conduct. It didn't dismiss any of this as it couldn't be persecution, but because we don't know why it happened, we don't know what drove the cartel to do this, and those are quintessential findings of Nexus. And with the court's permission, I'd like to reserve the remainder.
Yes, certainly.
Thank you.
Certainly, thank you. Mr. Hayes?
Good morning, Your Honors.
Good morning.
May it please the court, Timothy Hayes on behalf of the Attorney General. The agency correctly found no past persecution in this case. The sole harm to petitioner was a restaurant incident in 1999 in Mexico where persons he believed may be cartel members, but he's not sure which cartel, accosted him and people that were eating with him, and they were able to escape unharmed. I understand that they're trying to tie incidents to the family at large while he was in the United States to past persecution to himself, but that's not permitted under case law. There must be something tying those incidents to him in order for that to work. And I point the court to Chen versus Holder, which argues about the totality of circumstances. And also in that case, they cite a Second Circuit case called the Jing versus Holder, which talks about whether past persecution could work based on family member harm, and typically only in cases within the zone of risk.
What about the testimony from the petitioner that the cartel told his family members that if they didn't comply, that they would threaten and harm him? Isn't that a direct threat?
It would be a threat, but I don't believe that was never testified as far as I know. What they were citing to, I believe, was his declaration that he submitted with his asylum application. There was actually no testimony about the threats. The only thing I recall from the record was the last incident was in 2018, where the brother was murdered on Christmas Eve day, and then there has been nothing after that. I know Professor Mead was asked about whether the parents who are still living in the same home continued to be extorted, and he didn't know. No one knew. No one even knew whether these threats were continuing against the family as a whole. And that's kind of the crux of this whole case. It appeared to the agency to be more associated with generalized violence in Mexico than a targeted vendetta against the family, and that makes a world of difference, because that goes to whether petitioner has a clear probability of facing harm in Mexico if he were to go back. Obviously, to himself, he has a restaurant incident, but it was very long ago, and it wasn't enough to show past persecution. So we have to see a substantial risk of harm based on his particular circumstances. And he's trying to base it on experiences at random family members. And I agree the brother isn't random, but some of the other ones were more distant relative family members. And it wasn't enough in the agency's view to show a heightened risk.
So I'm sorry. No. The statement is, the testimony is, the question is, what did your mom tell you that the caller said to her? And the response is, they get threatened. They get threatened to pay the quota so that they are allowed to work, or else they will kidnap a member of the family, or a son, or a daughter, right? And so he's a son, and so why isn't that a direct threat to harm him if the family his parents didn't comply?
I believe that was made in like 2013. That wasn't a recent threat. And the problem is we don't know where these threats are coming from. We don't even know which cartel it is. So again, we have a bunch of random events happening to family members. And if it's not an organized vendetta against the family, it's hard to tie it to petitioner personally, especially in a past persecution context. All of the incidents to the family members that were discussed, the agency did analyze, but they analyzed it correctly under the rubric of whether it's a substantial risk of harm to him if he were to go back to Mexico prospectively. And in that regard, the biggest issue, or I guess the strongest evidence on their side, would be the murder of petitioner's brother on Christmas Eve day, and Professor Mead's testimony regarding that murder. The agency, and in particular the immigration judge, correctly rejected that testimony, as this is his prerogative, as not being persuasive enough to establish a link between the murder of petitioner's brother and petitioner himself, to raise the risk to petitioner that if he were to return to Mexico, he would encounter a clear probability of persecution. As far as the application under the Convention Against Torture regulations, the agency correctly found that petitioner did not establish a likelihood of facing torture. There was no past torture in this case. The incident, again, was a restaurant incident where he was thankfully able to escape unharmed. The immigration judge, Hsu, at page 80 of the record, said that there's no connection among the various crimes that have happened to the applicant's brother, but also more distant family members, to suggest that petitioner has any particularized risk of facing torture in Mexico above and beyond fears of generalized violence. Now, he did say, and that's under the regulation, that you do have to consider country conditions in the torture analysis, which he did, but he said here it's not enough with his particularized circumstances to suggest that he would face a clear probability of torture in Mexico. And unless your honors have any further questions, I would ask that you please deny the petition. Thank you.
Thank you, Mr. Hayes. Mr. Sedema.
Thank you, Your Honor. First, I just want to refer to short appendix page 4 and make clear what I was referring to with respect to the board's decision on past persecution. And in the middle of that page, he says, the board says, there is no dispute that the applicant has not experienced past persecution. As such, the applicant is not entitled to the presumption that his life or freedom would be threatened on account of a protected ground. The next paragraph proceeds to future persecution, and it continues to discuss certain facts in that context. So I just want to make clear, in case there's any confusion, that's what I'm referring to when I suggest that the board simply did not consider the issue. It found the issue undisputed, and I don't believe I heard any argument otherwise from the government. The second point I'd like to make is that it seems clear to me that the government's asking this court to weigh the evidence. It's asking this court to get into the merits of the issues, including past persecution, and they did not advance any argument just now that these arguments were not exhausted for the agency. Again, I just want to make clear, consistent with this court's practice, the board did not consider the issue, and it certainly did not discuss or analyze the issue in any depth at all. And in those circumstances, a remand is appropriate to allow the agency to address it properly in the first instance. My third point, there was some discussion of Dr. Mead's testimony. What was not mentioned was all the testimony that the agency did not consider from Dr. Mead, and I just want to quickly run through some of this. Dr. Mead explained how and why cartels target family members of their extortion victims to keep control over them and their property. He testified about statistics like the homicide rate, 59 deaths out of every 100,000, and how that just doesn't add up to somewhere between 6 and 9 members of your family being killed, kidnapped, extorted, and threatened. He testified that it does not look like random violence because people live in a violent town. It looks more targeted to me. It's a narrow circle of probability when you consider all of these violent offenses against one family, and he stressed that it's a combination of all of these things. None of that was addressed by either the immigration judge or the board at any point in either of their decisions. And finally, I might have failed to mention appendix page 229 in my opening argument. I think that's an important page. That is where certain key facts are presented that never found its way into either decision, such as the cartel pointing guns at my client at the restaurant. It was not just a confrontation, it was an armed threat. He also mentioned how he was asked, why does the cartel want to harm you? Because I am my father's son, and they want to harm me for this. And finally, I did not hear any argument on nexus, and I did not hear any argument on relocation. I apologize if I missed something, but the government has advanced no argument on those issues. And so for all these reasons, we request that the court remand.
Thank you very much.
Thank you.
Thanks to both counsel. The court will take the case under advisement. The next case for argument is 23-3140, Cobbs versus the United States. Good morning.
Good morning. Good morning, Your Honors. May it please the Court, Yevgeny Popovsky for the appellant, Michael Cobbs. May I reserve 2 minutes for rebuttal?
Yes. You have to watch your clock, but you could certainly reserve 2 for rebuttal.
The question before this Court is whether Boozley's reasoning applies to Mr. Cobbs' case, where the District Court determined that the government could have amended the indictment to bring additional charges. The District Court misapplied Boozley, and this Court should reverse the denial of Mr. Cobbs' Section 2255 motion. I'd like to make 3 points. First, the issue certified on appeal is narrow, whether Boozley's reasoning applies to uncharged offenses and open pleas. Second, Boozley held that the actual innocence inquiry does not extend to charges the government forewent independent of plea bargaining. And third, applying Boozley's principles here would provide a windfall to the government at the expense of Mr. Cobbs' constitutional rights. The first issue, that the issue certified on appeal is narrow, whether Mr. Cobbs must show actual innocence of uncharged offenses. The District Court here, which was the sentencing court, determined that Mr. Cobbs was convicted of an attempted Hobbs Act robbery, and that served as a predicate for count 2.
Do you agree that if you just look at the facts to which your client agreed and pled guilty, that those facts alone would support a Hobbs Act robbery conviction, not just an attempt?
Yes, Your Honor, the facts alone may support that, but evidence is not the crime of conviction. It's certainly used to be the actual basis for the plea. But here, the crime of conviction, was, as the District Court determined, was attempted Hobbs Act robbery, and that served as the predicate for count 2. In fact, the District...
Can you just clarify, you've been arguing actual innocence for purposes of getting around procedural default. What is your underlying merits claim? Are you using actual innocence as both the gateway to get around procedural default and your merits claim, or what's the merits itself?
Our position is if this court agrees that Mr. Cobbs has shown actual innocence, that he also would have succeeded on the merits, because here, as this court has held in Ruiz, there's a nearly per se rule that a unlawful conviction with a concurrent sentence is prejudicial to the defendant. And so we would argue that there was prejudice in Mr. Cobbs.
So the merit claim is not a constitutional claim. Is it a constitutional claim or a statutory claim?
The claim is constitutional, that he was convicted of a crime that is no longer valid, but there is also prejudice derived from that unlawful conviction in addition. So we would also argue that this case is fundamentally different than Boozley, because in Boozley, the court, well, in fact, Boozley rejected the line of reasoning the government advances here, that even if Mr. Cobbs pled guilty to only the attempted Hobbs Act robbery, charge, he still needs to show actual innocence of the completed charge because the government could have brought that based on this evidence. In Boozley, the court held that the defendant did not need to show actual innocence of a Section 924C offense because there was no record evidence that the government forewent that charge in obtaining the guilty plea. So our position is under Boozley, the court may not require Mr. Cobb show an actual innocence of the uncharged offense.
The actual text of count 1 of the indictment charges him both with a completed Hobbs Act violation and an attempted Hobbs Act violation, right?
Count 1 does track the statutory language, but the titling of count 1 says attempt, and this court has previously stated that if the indictment tracks the statutory language, that's certainly the beginning of the analysis, but that's not the end. And to the extent this court was to review if that was a technicality or an error, the court could look beyond the indictment to see if the defendant his substantial rights had been prejudiced. And here they were, because at the change of plea hearing, when the court asked the government what it needed to prove if this case were to go to trial.
You're not arguing that the title would trump what the substance of the count 1 charge is, are you?
We are arguing that the indictment needs to apprise the defendant with reasonable certainty, which is also, this court has found that fairly informing the defendant of the charges, the nature of the charges, should be with reasonable certainty, that at the bare minimum does not meet that standard with the internally conflicting presentation of count 1, and that is also consistent with the government's understanding of what the charge of count 1 was when, at the change of plea hearing, the court asked what it intended to prove the elements were if this case were to go to trial.
Well, that's for the charge to which he's pleading, right? I mean, that's the standard colloquy. Is you're not, as a district judge, you're not worried about all the other charges that the government says it'll dismiss later. You're just worried about to make sure there's a factual predicate for the charge to which the defendant is pleading. And here, the defendant was pleading to attempted Hobbs Act violation.
Yes, Your Honor. The government's position is that it did not dismiss any charges here, and that he pled to both. And we would point to the district court, which was also the sentencing court determination here, that I believe that this is RSA 12, that based on the indictment and the plea colloquy and the judgment, the predicate for count 1 was attempted Hobbs Act robbery. I'd also like to make a point that extending Boozley here, Boozley's principles here, would provide a windfall to the government, unlike in Boozley, because here our position is the government charged attempted Hobbs Act robbery. That is what it proceeded with at the change of plea hearing, and if it wanted to convict Mr. Cobbs of completed Hobbs Act robbery, it would have need to either obtain and it would have to obtain a grand jury indictment on that charge, and if he chose not to plead to those charges, it would have had to prosecute those charges at trial. But what the government can't do here is cut corners, where substituting the predicate offense that Mr. Cobbs did plead to with an uncharged offense now that the crime of conviction is invalid.
If I could ask you about the merits question again that Judge St. talked about. So as I understand it, we'll make sure that my understanding is correct, that on the merits, you're arguing that because of Taylor, attempted Hobbs Act robbery no longer qualifies as a crime of violence under Section 92(4)(c)(3)(a), and I mean that's the basis for the merits claim, right?
Yes, sir.
And so, isn't that a statutory interpretation? Didn't Taylor engage in statutory interpretation rather than a constitutional grounds for the decision?
Yes, Your Honor, but here Mr. Cobbs is now imprisoned for a crime that is no longer valid, so we would also argue that is a constitutional challenge.
But didn't we say that there is no freestanding constitutional violation for that particular, so being actually innocent, and that really is in itself is not sufficient for a constitutional violation?
I might have to look back at the briefs, Your Honor, but in any event, if it is a statutory challenge, we still argue that Mr. Cobbs succeeds on his actual innocence claim and then subsequently on the merits.
I know this issue that we're asking about wasn't raised or briefed, but we have case law that says that actual innocence can't be a standalone claim, that it's a gateway to get excused procedural default, but it's not necessarily a standalone claim. And we've said that in the Lund case fairly recently. So that's what these questions are getting at. If you prevail on your actual innocence, then what?
I understand. Well, the issue certified on appeal is whether the court properly excused the procedural default. So at minimum, we would ask that this court reverse that order and remand for further proceedings.
Okay. Thank you. Mr. Miller.
May it please the court, counsel, to address that. This is clearly a statutory claim. The defendant wants to bring a statutory claim, and if we were here on direct appeal, the defendant would be in a much better position. But, of course, to bring this statutory claim in this 2255 context, the defendant is stuck with his procedural default. He pled guilty to the 924C count, which is the count being challenged, not the count 1 Hobbs Act count. He pled guilty to it. He didn't appeal it, so he procedurally defaulted it. And as Bowsley says, it's the extraordinary case where the court will excuse a procedural default, especially in the case of a guilty plea, and that requires either cause and prejudice, which isn't his issue here. They've conceded they don't have that, or actual innocence. And as this court knows, that actual innocence is factual innocence. That's not legal sufficiency. And as the defendant admitted, as he has to on these facts, this defendant is not factually innocent of committing this 924C offense.
So what's the government's view? If he is actually innocent for procedural default purposes, then what?
Your Honor, the department's position has been in those cases to go ahead and waive those defenses we would have, because it's not a constitutional claim. At least it has been. Policies seem to change daily here with the department, but that has been there. So we would agree, if you would find that it was not procedurally defaulted.
Or that
I'm sorry.
Actual innocence excuses the procedural
Exactly.
default.
If you would find that excuse,
Then what?
We would think in this case it would be remanded to the district court, because the district court didn't get to the merits at all, to allow the district court to address the merits and allow the parties to raise whatever arguments they would raise in the district court.
So the position that the department has taken through now, to your knowledge, is that even though the merits claim is based upon statutory interpretation, that the government would allow the petitioner to raise that in the district court on the merits.
It gets more complicated because the policy is we generally don't raise those defenses unless we believe the defendant is not actually innocent. If that makes sense.
Yeah.
So in this case, we, as set forth in the brief, I believe we would raise those defenses because we do not believe under these facts where the defendant was on supervised release for an armed credit union robbery when he committed this very violent crime by brandishing a weapon, taking money, taking cell phones, the defendant is actually innocent. And where I think the defendant's argument, as he started, is off basis, it talks about the government is wanting to amend the indictment. That is not the case at all here. The indictment is very clear. Count 1 charged both in the conjunctive a completed Hobbs Act robbery, there's no dispute at that, and an attempted Hobbs Act robbery. More important, count 2, which is the count that the defendant is challenging, charged that the defendant possessed and brandished a firearm in furtherance of a crime of violence that was a felony prosecutable in a court of the United States. That is a violation of Title 18 United States Code, Section 1951, as set forth in count 1 of this indictment. That didn't say as pled guilty to in count 1 of the indictment, right? He's charged with the 924C as set forth in count 1 of the indictment. And what is set forth in count 1 indictment is both a completed and an attempted Hobbs Act robbery. And really, any completed Hobbs Act robbery is going to set forth an attempted robbery because it's a lesser included offense of the completed offense.
I think you would agree that if he had only been charged with and had only pled guilty to attempted Hobbs Act robbery, that the 924C couldn't stand, correct?
We would agree with that, Your Honor, in this situation, and that we would not have in that case asserted, because that's really the Bowsley case. Because you look at Bowsley, that was a 924C case back when Bailey decided that use couldn't include possession. The defendant had pled guilty to use based on possession. And the Supreme Court said, yes, if the government didn't charge him with carrying, so on remand they can't try to prove up carrying. But they also said that because, as far as the use went, that the government would be able to quote it, the government is not limited to the existing record to rebut any showing that the petitioner may make. On remand, the government should be permitted to present any admissible evidence of petitioner's guilt, even if it was not presented during the petitioner's plea colloquy would not normally have been offered prior to Bailey. And that's exactly this case here, in the sense that regardless of what the defendant pled guilty to on count 1, he was charged with a completed Hobbs Act robbery in count 2. He pled guilty to count 2. And so the government, in fact, this case is stronger than Bowsley, because in Bowsley, the only evidence that was presented of use was the possession, which Bailey held didn't qualify. But in this case, the factual basis presented a completed Hobbs Act robbery. So the defendant pled guilty to count 2 based on a charge of a completed Hobbs Act robbery and evidence of a completed Hobbs Act robbery.
So if he is not, if we find that he's not factually actually innocent, do we even have to get to Bowsley?
Bowsley really addressed, I think Bowsley just is the framework for the court finding in this case that that he's procedurally defaulted his claim and there's no excuse. In Bowsley, the reason is it hadn't been raised in the district court, the actual innocence, and the government didn't assert waiver, and the Supreme Court said, well, since that's the case, we'll remand for him to attempt to prove actual innocence. Here, of course, we're not in that situation because the defendant already attempted to prove actual innocence, and he can't.
So Bowsley talked at the near the end of the majority opinion. It talks about the fact that there's no record evidence the government elected not to charge petitioner with carrying a firearm in exchange for his plea of guilty. That is something that wasn't in the indictment, right? And so here is the government's position that the government actually did make an election not to proceed with crimes that were charged in the indictment?
I think yes, and I think I'll put it in this way. I think we know what happened here, which is that it went forward to the change of plea on count 1. It was, as we spent some time in the brief discussing, it's unclear. I think an argument could be made he pled guilty to completed. An argument could be made he pled guilty to attempted. It didn't matter to the parties at the time. It didn't matter to the defendant. It didn't matter to the government. It didn't matter to the judge. It never mattered to the probation because it didn't affect anything at the time. So our position is what is relevant is that he was charged with a completed Hobbs Act robbery, and that therefore to prove actual innocence in this context under Bowsley, just as extended, he has to show that he was actually innocent of that crime with which he was charged. If he hadn't been charged with it, we'd be in a very different situation.
So your position is because he was charged with it, had the government had the benefit of Taylor back then, the government would have proceeded with getting a plea with the same facts on a completed Hobbs Act. I
could unequivocally state that if Taylor had been in existence at that time, the government would not have accepted the plea to an attempt, would have required a plea to the completed Hobbs Act robbery, and if it hadn't got a plea to that, it would have gone to trial on that charge. So the windfall that the defendant claims is the government's is not the government's windfall. In fact, as Judge Myerscough found in her opinion, under these facts and circumstances, it would be a windfall to this defendant who pled guilty to the completed Hobbs Act robbery to, at this point, be able to go back and make the statutory challenge to the statute.
How do you respond to Cobbs's fair notice concern that the indictment says attempted, the government said he was pleading to attempt when setting forth the elements of the plea, the PSR refers to the attempt, and he's raised fair notice?
Well, the answer here is that what he pled guilty to in this context really doesn't matter as far as count 1 goes, because he hasn't challenged. Bowsley was actually a challenge to the guilty plea, whether it was voluntary. I didn't make an intelligent plea, the defendant said there, because I didn't know that possession was no longer used. The defendant has never raised here anything regarding his plea of guilty in this case. He's never raised that. So that's really not at issue here. The idea of fair notice or whether it was an intelligent plea, because it hasn't been raised. And to the extent he would be raising it now, it would be waived in the district court, and the United States would assert that waiver. So the question here simply is, can he establish factual innocence, that he's actually innocent of that 924C charge in order to get to the merits of his claim? And the record is very clear. The government charged a completed robbery. He committed a completed robbery. He is not actually innocent of that 924C. In fact, I believe the evidence shows beyond a reasonable doubt he is guilty of committing that 924C offense for brandishing that firearm during a completed Hobbs Act robbery, which is a crime of violence. If there are no further questions.
Thank you, Mr. Miller. Mr. Poposky.
The government here says it doesn't matter what the defendant pled guilty to. We would argue that it does matter because the defendant is entitled to know the nature of the charges that they are pleading guilty to. And the brief but very clear exchange with the court at the change of plea hearing asked, do you plead guilty to attempting to rob the restaurant? Yes. Did you show a gun during that attempt? Yes. While there might be some uncertainty elsewhere in the record, that brief exchange, we would argue, made clear to the defendant what he was pleading guilty to. And I wanted to clarify a point on the actual innocence inquiry. The actual innocence inquiry can be factual, but we are here arguing what the scope of that inquiry is. And under Lewis, it recognized that Boozley limited that scope to a crime of conviction, as well as any charges that the government may have foregone in the course of plea bargaining because of the undue benefit that the defendant may have received because the government dropped a charge in the course of arriving at that plea. I see my time is up.
Thank you. And I understand you and your firm accepted an appointment in this case. Thank you very much for accepting the appointment, for your service to the court and to your client. The court will take the case under advisement, and thanks to both counsel. Our last case for oral argument this morning is 23-3368 U.S. versus Curtin. Welcome back, Mr. Roy.
Thank you, Judge. May it please the court, Attorney Michael Roy on behalf of appellant Dana Curtin. This court should vacate Mr. Curtin's conviction and remand for a new trial with Dr. Sala's testimony. I want to briefly talk about a harmless error, since that is often an issue in these sort of like To Catch a Predator style sting operations. And the main point I want to make is that when compared to, I know this court sees a lot of these sting operations, this is kind of the borderline of what is the bare minimum necessary to convict someone, I would argue. Judge Lee, I know myself and Mr. Simpson recently argued Austin McLean's case in front of you. I think that was actually the same undercover agent as this case. That's a good example of what the text messages normally look like. Giving nude photos to the minor, describing very graphically what sexual activities they want to perform. I know everyone on this panel has probably worked on a ton of these cases, seen a bunch of these. Judge Maldonado, I'll confess, I'm not sure how many of these cases you've personally worked on, but we have on pages 36 and 38 of our brief what I think are some good representative examples, and that's only scratching the surface. That's only from this circuit as well. A brief overview of the law will show lots of cases where usually the text messages at issue are much more graphic than what was here. And I think that's why Dr. Sala's opinion was so important, because that was rebutting the one big piece of evidence the government had apart from the text conversation, which was their argument that Dana Curtin's habits with like obsessive adult pornography consumption, obsessive solicitation of adult prostitutes, the government used that to argue that his sexual appetites with adults was evidence of an intent to also have sex with a minor. And that's what Dr. Sala could have rebutted both of his opinions that we're arguing about.
Can I clarify exactly what opinions you wanted to elicit from Dr. Sala? I think one was clearly that wanting to have sex with an adult is different from wanting to have sex with a minor. But what other opinion did you seek to elicit from him?
Sure, and I think maybe this is going towards the waiver.
It is.
Between the parties.
It is, yes. So I want to clarify and make sure I'm not missing something, because there were some arguments made about opinions on intent that I just don't see in his report as disclosed. But other than, could you explain to me, please,
Sure.
what it is that you sought to elicit?
And I will concede some of the arguments come off as a bit muddled from the trial record.
Yes, that's why I'm seeking clarification.
But I think that the two easiest points I'd point out is, first, the Britton pretrial filings. He filed a report, and he said his main opinion was, I evaluated Mr. Curtin in person, plus reviewed a whole bunch of other documents.
Right.
And my opinion is he does not meet the criteria for pedophilic disorder or any other paraphilic disorder. And specifically, he doesn't meet it because he lacks the sexual urges, sexual interests in children. That is a DSM-5 criteria.
And is that the opinion that you wanted to elicit, that he does not have the criteria for the pedophilia disorder?
Exactly. That is one of the opinions.
Okay, then why didn't you waive that?
I would point again towards the pretrial motions, in that Curtin very clearly waived any argument that a lack of pedophilic disorder is an affirmative defense, and we aren't arguing that on appeal either, because that would...
Before the court, though, this representation was made that counsel agreed with the judge that you were not, I'm quoting, not trying to call the expert to talk about pedophilia.
I believe you're pointing to page 7 of the transcript.
I don't have the precise page before me, but that is a quote. So I am trying to understand how, with that and then various other representations, how you have preserved
I think it's
that
looking at
issue.
the context. In the written filings, I'm not sure what else it would have been they would be calling Dr. Solita to say, if not, he lacks these sexual urges,
That's why I'm asking these questions,
Right.
because although, as you said, the record is a bit muddled, because there were arguments that about intent and potentially trying to use this for intent, which I did not understand what those were and where those had been disclosed, because that looked like something different than what we're talking about now.
Sure. I understand that. Although I will point in page 11 in the response to motion limited, they do say he's going to give his opinions about his diagnostic testing. It's at the very top of page 11. And the government's quotes for waiver, I think the written ones are easy to address, since those are all very clearly about the sort of, like maybe what's like NGI type defense that they're disclaiming, right? Now, the oral statements, the one you were just pointing to, Judge, about won't talk about pedophilia, I think in context, that's also saying he's not going to opine on the ultimate issue or say that a disorder is required to have intent. Right after defense counsel says that, she goes on to say, but he will testify about the diagnostic criteria. I don't know what else that could be referring to.
The response from defense counsel, the district court specifically said, expert testimony on a diagnosis or lack thereof of pedophilia disorder is not admissible. And defense counsel agreed with the judge. So how was the court supposed to know that this issue, that you were still trying to admit?
I think it's in the same paragraph but we do want him to talk about the DSM-5. We do want him to talk about the criteria of the DSM-5. And then going on, the government understands the defense's argument to be eliciting an opinion about whether or not he has a sexual interest in children. Page 8 of the transcript, the government's saying, the defense is still saying they're going to present the same thing. It's at the top of page 8. Experts' opinion is to talk about the different factors that go to intent as they relate to DSM-5. All that gets back to some diagnosis, which is irrelevant. That was the government's response to the defense's position. Same thing with the middle of trial on page 321 of the transcript, where they say, we're not going to solicit an opinion that he has pedophilic disorder. The government says that it was supposed to say that he does not. I think in context they're, again, saying, we're not going to solicit an opinion that pedophilic disorder is a defense. And then going on, they say, we'll testify about the diagnostic criteria. And once again, on page 326, the government is still arguing that the defense's argument is that they're going to elicit some sort of opinion about a diagnosis that they say is irrelevant. So the government thought at the time that defense was still going to push this. I'll also say, even if this can be construed as defense waiving or disclaiming any opinion that he lacks a formal diagnosis. They were still repeatedly clear that they wanted to solicit the opinion about the criteria and whether he met the criteria. So even if Dr. Tilley did not say the final thing, I opine he does not have pedophilic disorder, I think the defense was pretty clear that they wanted him to say he does not have sexual urges towards children, he does not have sexual fantasies about children. And like really that's more the pertinent trait than what the diagnosis is anyway.
So then, why does it matter, right? Why is that relevant? I can see how the presence of a disorder might make it more likely than not, when a person is compared to general population. But the absence of a disorder, why is that relevant to intent when the expert, I think it's himself, right? The expert himself said that, whether or not you have pedophilic disorder does not really mean anything about whether or not you're going to commit the crime.
Sure, and I think that's the only way that any opinion like this could ever come in. Like, there's no expert would be allowed to say he has no pedophilic disorder, so he could not have had the intent. That would have been an opinion on the ultimate issue intent, which is not allowed. So he was just fitting within the guardrails. This court has been very clear. Rule 702 does not require them to give opinions on an ultimate element. It doesn't matter if the opinion would negate an element directly or not.
So when he said it's not relevant, you're saying that it doesn't mean relevant in the 401 sense. He means relevant directly with regard to the question of intent? Like, right. So,
yes,
right?
My understanding of Dr. Tilley's testimony is that he would not have opined on the ultimate issue, but he would have given the opinion in terms of, he's not a lawyer, he's a doctor, right?
So then it comes to my question is, why is the lack of a disorder relevant at all with regard to the charge in this case?
For the same reason that any pertinent trait is relevant in a criminal
But it's not, it's a lack of a trait, right? It's not that you have a trait, it's the lack of a trait. So, no, but I think because if you think about the lack of a trait, that's the general population, right? And so its probative value would certainly be much less compared to the presence of a trait, because the presence of a trait distinguishes you from the general population, whereas the lack of a trait does not. So I'm curious as to why the lack of the pedophilic disorder would be relevant to this case.
I think maybe there's a metaphysical question there too, whether a lack of a trait is a trait or not. I would say it still is a trait. And I'd point to the D.C. Circuit's case in Haidt, where they reversed for a court that left out very similar testimony. I'd also point out that the government was trying to make the argument about his sexual interest. The government had put it into issue, and there was a lot of evidence about him going to escort website essentially. So this would have been directly relevant to pointing out what his interests were. And I see I'm out of time.
I'll give you an extra minute for rebuttal.
Okay. All right. Thank you, Judge.
Thank you. Mr. Simpson?
Hello, Your Honors. May it please the Court, I'm Scott Simpson on behalf of the United States. First of all, in relation to waiver, I think what we are seeing here, and I think this comes out in the district court record and the transcripts, I think we're seeing that the defense was shifting its arguments in response to the government's motion, in response to the district court's reaction. They were shifting their arguments in an attempt to find a formulation for Mr. Saleh's expert testimony that the district judge would accept. In their expert disclosure, they said that Dr. Saleh would testify that Curtin did not, quote, meet the diagnostic and statistical manual's diagnostic criteria for pedophilic disorder or any other paraphilia disorder, close quote. Didn't say, I have to differ with defense counsel, it didn't say that was going to be the main focus of Dr. Saleh's testimony. It's a very short report. It said
but that wouldn't be waiver. If it's disclosed, even if it's not the main focus, just the mere disclosure of the pedophilia tendencies opinion would be sufficient.
But, Your Honor, that was waived not because of what the report said,
Yes.
what the disclosure said, but because of what defense counsel said.
I thought you
later.
were arguing that wasn't sufficient.
No.
Okay.
That would have been sufficient if they had not withdrawn. Basically, they withdrew that argument. They withdrew that offer to have the expert testify on that. That's what they were saying initially. That's all they were saying initially. But
And
then
that was
when the-
partially in response to the fact that the government had disclosed a witness.
partially,
and that
yes, Your Honor.
the government ultimately elected not to put that
Correct.
expert on the stand.
Correct, exactly.
Which probably took away some of these arguments from them, and it seemed like that's when the shifting started.
Possibly. But as you look at the transcripts, it seems like mainly what took it away, what caused them to change their approach here, change their tactic, change their argument, was basically the district court expressing doubts about accepting expert testimony on that issue, that is the lack of a diagnosis. And so, as the court has already referred to, once the district court expressed doubts about accepting expert testimony on that diagnosis, defense counsel said, okay, quote, we're not trying to call him to talk about pedophilia, close quote. Rather, at that point, they said they just wanted Dr. Saleh to, quote, opine about the factors that a jury would consider in determining whether or not someone had the intent, close quote. That's not the same. That's not the same as the diagnosis. That's not the same as talking about whether Mr. Curtin had pedophilic tendencies. That's just general factors that the jury could consider.
And was that disclosed? I didn't see that disclosed in
It
either
was
the
not,
initial
Your Honor.
letter or the subsequent report.
It was not, Your Honor. It actually was not. And then the defense, after that point, the defense never again said that they wanted Dr. Saleh to testify that Curtin did not have pedophilic disorder or pedophilic tendencies. As the discussion continued, and as you see in the transcript, this was quite some long discussions with the court. They reiterated the argument about having Dr. Saleh talk about what factors the jury should consider in determining intent. They brought up that Dr. Saleh could testify that a sexual interest in adults doesn't necessarily support a sexual interest in children. So crucially, another fact here in the record that supports the fact that they waived the argument is the district court did not rule on whether the defense could present expert testimony that Curtin did not have pedophilic disorder or pedophilic tendencies, since that was no longer what the defense was arguing. And when the court gave its ruling, saying, no, I'm not going to let Dr. Saleh testify, the court referred to this concept about, a sexual interest in adults is not a sexual interest in children. And at that point, the defense counsel could have, but did not say, I'm sorry, Your Honor, hold on a moment. How about testimony that Mr. Curtin does not have pedophilic disorder or pedophilic tendencies? They didn't do that. So unfortunately, the defense here on appeal has to live with what defense counsel said and did below. So on the merits, along the whole continuum of district court decisions about evidentiary rulings, this decision here about admitting an expert under Rule 702A, that's pretty close to where this court, I think, gives the district courts the greatest deference. Would the proffered expert testimony help the jury understand the evidence or determine a fact and issue? That's the very generality of that language from Rule 702A reflects that this court should defer to the district court. This court has said it will not overturn a decision on that question unless, quote, no reasonable person could agree with the district court's decision. And there are many reasons, and unfortunately on the question of pedophilic disorder or pedophilic tendencies, unfortunately, because of the waiver, we have to talk about what the district court could have reasonably decided, could have decided within the applicable standards, since the defense's position deprived the court of an opportunity to actually rule on that subject. Primarily, I think we need to look at Rule 702A. As I said already, the elements of attempted sex trafficking do not involve proof as to whether the defendant has pedophilic tendencies, as the panel has already observed, seems to be irrelevant. And as, of course, part of the reason why it's irrelevant, as the defense itself, I think, acknowledged below, someone without those tendencies could commit the offense and vice versa. And then Rule 403, which is also important here in relation to expert testimony. The risk of distracting or misleading the jury would have been especially great in this case in light of, to paraphrase something this court has said, in light of the aura of special reliability that often surrounds expert testimony. And then on the concept of the concept that sexual interest in adults does not indicate a sexual interest in children, the court did rule. The district court did rule on that one, and the court was obviously correct in observing that's a common sense thing for all of us. No expert testimony was needed for that common sense proposition. In its briefing, the defense asserts, and I believe defense counsel alluded to that, to this argument this morning, the defense argues that the government opened the door to that kind of testimony on that subject from an expert for the defense because of the government's own evidence about Mr. Curtin's sexual activities involving adults. But factual evidence, which is what the government presented on that subject, factual evidence about Mr. Curtin's conduct is very different from expert opinion testimony, both in its basis and in its potential impact on the jury. The defense could argue, and in fact, I believe below the defense did argue at trial that Mr. Curtin's sexual interest in adults did not suggest a sexual interest in children. In fact, the defense put on testimony to that effect that from his wife, I believe, also from, I think it was a school teacher, that they had never seen Mr. Curtin act inappropriately around children. And finally, on harmless error. Aside from all of this, even if the district court did make any error, we submit that it was harmless. Evidentiary errors warrant reversal only if there is a quote-unquote significant chance that they affect the outcome. Now, granted, in this case, there wasn't quite as much evidence as there are in other cases to support the jury's guilty verdict, but still the evidence was pretty overwhelming. Among other things, Mr. Curtin continued this conversation with the father for 10 weeks. He repeatedly reached out to resume it. He complained about being ignored when there was a lull in the conversation, when the agent delayed in responding to him. He said he would love to get together. He said he had forgotten the girl's looks at one point, and he came to the meeting with the agreed amount of currency to pay for the encounter in a separate part of his wallet. So, Your Honors, for all these reasons, and there are many different bases on which the court could affirm, whatever basis the court believes is most appropriate, we urge the court to affirm. Thank you.
Thank you, Mr. Simpson.
Could I ask one?
Oh, yeah, sure.
Mr. Simpson,
Yes.
what to me, what makes this a closer call than it should be is that the government, it seems to me, did not just say, oh, well, he likes to have sex with adults, so he must like to have sex with children. I think the government's focus was on his, what it would characterize as abnormal or atypically voracious appetite for adult sex, like prostitutes, et cetera, right?
I think one of their briefs says excessive.
Right. And that makes this, to me at least, that makes this a closer call because by relying on that, I think a jury might more readily transfer that because it's excessive and quote-unquote atypical or abnormal to liking sex with children because that too is kind of atypical and abnormal. And so it seems to me closer to the line than if the government were just saying, well, because he likes to have sex with adults, he likes to have sex with children. I wondered if you have a response to that.
Your Honor, like I said, the defense pushed back on that, on the government's evidence along those lines, in two different ways. The argument, they argued as they could that the sexual interest in adults didn't necessarily suggest a sexual interest in children. And they did, as they could have, they did present evidence, quite a bit of evidence, in an effort to show that Mr. Curtin did not have a sexual interest in children. All of this is factual evidence. The government brought in Mr. Curtin's own activities, and the defense brought in other evidence as to his activities or lack thereof. Here we're talking about factual evidence, whereas when we're talking about expert testimony, we're getting, we think, into a whole other area, partly because of that aura of special reliability. So I think we need to be especially vigilant in relation to, or especially deferential to the district court judge in relation to expert testimony for that reason.
Thank you.
Thank you.
Thank you. Mr. Roy, we'll give you 1 minute.
I do want to pick up off the thread that you all just ended on, sort of with the common sense argument and whether it was necessary to have expert rebuttal. I would point to the government citation to Davenport, which is an unpublished case, but it describes the basis for why this court previously allowed sort of expert testimony about like pedophilic habits and this sort of habit testimony. It explains that what jurors know or think they know about criminal conduct, it's right, is an important question on which social science can be illuminating. Disabusing jurors of mistaken common knowledge and helping them sift facts from suppositions are important functions of experts. That was directly talking about, sort of pedophilic tendencies. And I think the short answer is that human sexuality is complicated. We don't know. There could have been a juror who visited the same brothels as Mr. Curtin and thought this was all normal behavior. There could have been a juror who thought that anyone who looks at any pornography is one step away from a sexual assault. We don't know what the juror's assumptions were coming in. And with the evidence that he already was outside the general population, rebuttal both on what the shape is of his deviant traits and also why those deviant traits don't carry over to other deviant traits, I think was important. Unless this court has any other further questions.
No, thank you very much.
Thank you.
Thanks to both counsel. The court will